Thank you, Brigadier. Let me ease your mind. The records of accused number 3's cell phone, as they also cover the period of that 26th of October 2014, had already been disclosed to the defense at the very inception of this trial. So, it strikes me very strange in terms of the nature of your investigation to say that you were not even aware of those records.
That could not be correct. Yes.
I mean, I can remember the evidence.
Yes.
For this case. Different case.
The records that were disclosed as the witness testified were those ones from the from November 2014.
I did not get the gist of the objection, my lord, about the disclosure of
they say the objection is not clear, Mr. Baloi.
Yes, indeed.
Maybe I did not hear the statement because something distracted me.
Well, the proposition that the cell phone records of accused number 3 covering the period 26 October 2014 were already disclosed at the time when there was a general disclosure. We objecting to that, and the basis of the objection is that that is not correct, my lord.
As it is a court, my lord, it is incorrect to say that those records were already disclosed to the defense at the time when Mrs. Pinky Vitilinga was testifying. I became aware of that Section 205 record when I was preparing for this trial, and they were contained in Cleveland tests in yellow pages. Now the question is, if really this case was investigated to the manner in which it is to be assumed that it was investigated, how can then Brigadier Gininda say that he was not aware about this so important piece of evidence when it was disclosed to me, I think last year, May? Thank you, my lord. That's the question that I'm directing it to. I'm not lying to court. I won't mislead the court. That's the question that I'm directing to the Brigadier. I don't know if the state would also want to clarify that as well.
My lord, that cannot be true.
Listen, they have taken an early adjournment and then they'll take lunch. But then when they come back from lunch, guns are drawn right now, okay? Guns are drawn right now. Mnisi has put his on the table and Gininda has put his on the table, and both men are saying they are correct. So the question becomes, who is actually right? Mnisi says, what are you talking about? What kind of an investigation did you do? Because I had these Section 205s that definitely, okay, include the 26th of October 2014, and Gininda saying, you're lying. You're lying, and you know what? You definitely, I will go even further to say you are misleading the court. What? The tension is high, okay? The Pretoria North High Court is on fire. Somebody has thrown an explosion there, and I don't even think there's any fire. There's any firefighters that can assist, okay? Mnisi better find those papers. Mnisi better find those papers. Because the judge says he remembers, okay, that was for another case. Baloi says, not true, my lord. The records are from November 2014. Gininda says, not true. Is Mnisi standing alone? At the end, you see him with the other defense attorneys huddled up and, gathered to laugh. I'm assuming they're laughing at Gininda. They've had this ace up their sleeve. And this is what I mean when I say, you know what? Keep the information until the very end. Stop disclosing stuff ahead of the witness being on the stand. I advocate for this. And if this is true, if Mnisi has got these records, these yellow page records, this is going to be fun. It's going to be fun to see how the judge is going to react. Is the judge going to backtrack on his words? Because he listens, he listens. Mnisi is assertive. Mnisi is firm. He has had these papers before the trial started. Pinky, where are you? Pinky, where are you? But you have to hear what Gininda says yourself. And also, I want you to pay attention, okay? Look at accused number 3's t-shirt. I want to say, and I want to boldly say, or I want to insofar and is say, oh gosh, how does Gininda say it? I want to go so far as saying he hasn't worn this t-shirt since Boksburg Magistrate Court. Remember the t-shirt? If you do, type the words in the comment section down below what his t-shirt says. Did he know Advocate Mnisi was dropping this bomb today? Did he know today was the day? Because he has been laughing all day. And whenever Gininda, he has been bursting out laughing. Do you think accused number 3 knew the game plan? And that Advocate Mnisi had this ace up his sleeve. But you know what? Let me let you listen to Gininda.
My lord, that cannot be true. It's absolutely not correct. I think one can even take it to the greatest form that it is misleading to say that, to say the least. It's not true, and if that is assertion that it is the truth, then it's misleading. Because the docket is indexed, my lord. When you get evidence, you index it. What was found initially, my lord, and I know we dealt with this part with the forensic team and the state advocate, was that the first records that were applied for, insofar as the Cleveland case is concerned, Advocate Mnisi is correct in that part, only started in November. I think that's why he's making November. Those are the ones that were able to discover during the course of the investigation, and those are the ones that were disclosed to them. We had no knowledge of the second bunch of records. Why did we have a knowledge? Did not have a knowledge, my lord? They were applied differently. Even if you look at the reference number of what you call the case file, the first bundle that we disclosed had a different case file than the one that was discovered by Pinky Vetelingham. So it was not records that were available. For some reason, my lord, they were kept away from us. It is through the exercise with Pinky Vetelingham when she was asked to conduct a search on the number that this other set came up. When it then came up, my lord, that's why I refer that it came up around the period of consultation and subsequent to her evidence. Then during that time, my lord, they were then disclosed to the defense for the first time, and we filed them in the docket. So the assertion that they were given to the defense prior to the commencement of this trial, my lord, if they have it, then they don't have it from us, my lord, because the docket does not have such a recollection recordings, first of all, and that goes to the cell phone analyst, Kenneth Stein, who analyzed these records. That is why, my lord, the person who dealt with this is Kenneth Host, because they came around during his period. Kenneth Stein did not have access to this, and the court will recall that part of the exercise that I've asked him to do when Kenneth Stein started as a cell phone analyst, my lord, was the following, and I've dealt with this part. First, I said, this is what is contained in the docket in terms of the cell phone data. Authenticate it. Secondly, I said he, as a cell phone analyst, because I'm not an expert, he must go and authenticate what we have in relation to what he finds in the database of the police and the service providers. And he came back and said, what we have here, this is what I have, so I can authenticate it. Nowhere, my lord, even himself, was he able to discover these records that mysteriously were kept hidden somehow, my lord, and surfaced when the expert then came to testify. So that assertion is not correct. That is how things unfolded, and they were authenticated. They were not there. So we investigated, my lord. They were not made available. They were not in the face of what we would have uncovered during the investigation.
As it pleases the court, my lord, I'm going to request for a short adjournment. It's almost 20 minutes to lunchtime. I'm just about to wrap my cross-examination. However, I still need to pursue this point, my lord. I want to introduce those that record that is being disputed or denied by the state. Then it was made available to us at the very inception of this trial, actually even before the accused were made to plead to these charges. I want to introduce it as a fact, something that is tangible. So I would request that we take an early adjournment. So I go prepare them and then I'll come present them at 2 o'clock. When I come and finalize.
We've got a list here of all the exhibits in this trial. Don't we have some? All.
Yes,
And then we go from 1, I think, up to 170 something. What was the citation? Meaning, in other words, Mr. Mnisi, the very record you say was disclosed,
yes,
it will be in the exhibits which are given to the court. Unless I was not given that exhibit. If I was given that exhibit, there is a list.
Yes.
Where you just have to read the list and you see.
Yes.
Evidence of so and so.
Yes.
Yeah. So what's the problem? Why should we not just go and inspect that list?
With due respect, madam, I'm not talking about the list
What are you talking
of
about?
exhibits that had already been handed over to court. I'm talking about disclosure, the information that was handed to us by the state when we were supposed to prepare or when we had to prepare for the trial.
So
I'm talking about that information.
I hear you. Are you saying the state used evidence which they never disclosed to the court, in other words?
No, my lord. I never said it. I am saying, my lord. I am saying, my lord,
Yeah.
because the brigadier said in his evidence
Yeah.
that he became aware of the record of the cell phone record of accused number 3 upon the testimony of Mrs. Vitiliam. And then I'm saying to him, no, but it cannot be so, because we already had that record when we had to prepare, when we had to start to prepare for this trial. In other words, that record has been there even before Ms. Pinky Vitiliam could come and testify. And then the brigadier says no. Then if we have that record, they don't know where we got it from.
Okay, that's a gentleman.
Thank you, Manoj.
Just before I adjourn, just so that there's no misunderstanding, the brigadier refers to the cell phone records of accused number 3 that covers the period 26 October 2014.
I'm talking about that as well. Thank you.
Which records are supposed to be prescribed?
Well, the records were there. They were asked by the previous team, Manoj,
Yeah, okay,
in the other case, but not disclosed to the current team.
We come back at what time? 2 o'clock.
If Mnisi is saying he has the records and he wants to go and get them, why on earth, somebody help me understand, why on earth is Baloyi trying to argue that Mnisi has what he says he has? Why can they not let him go get the record or fail to find the record and then come back and say it? But oh no, there goes Mr. Squatting. Okay, he's already objecting to what Mnisi says he has. How can you object to what he says he has? I mean, this is absolutely ridiculous. But yeah, after lunch we wait. So it's TikTok. Oh, I cannot wait. Let me know your thoughts in the comment section down below. What's your prediction? Does Mnisi have these yellow pages? Yes or yes? Oh my god. Let me end the video here. Okay, I definitely want to keep this one nice, short and sweet, and I'll catch you on my next upload. Don't forget to like, comment and subscribe. Okay, thank you. Mzansi Unfiltered checking out. Catch you on my next upload.
My Lord, I'm indebted. Yeah. As the court pleases, my Lord, I'm indebted. Yeah.
If the grooves don't fit, acquit the 5 accused. Mnisi has done a fantastic job proving there was no match.